Hello students, welcome to La Excellence. Welcome to the explanation video session for test 1 part 2. In this particular session, we are going to deal with the polity questions that are asked in test 1. The first question is given in question number 1. This question says, the necessity of fundamental rights in a constitutional democracy means the need or necessity for the fundamental rights is what? That is the question. Here if we see the options 1, 3, 1, 2, 4, 2, 3, 4 and 1, 2, 3. Here if we observe, 1 is there in 3 options. So we can probably say 1 might be correct. Or if we can eliminate 2, 2 is there in 3 options. So if we can eliminate 2, we can eliminate 3 options. So answer becomes A. So let's go to the question, read it and let's see. First point says, promote ideal of political democracy. Political democracy is the ideal of fundamental rights. By preliminary reading of fundamental rights itself, we can say it promotes political democracy. So it is correct. So let us eliminate C. Now, second point, prevent establishment of authoritarian rule. Let's say we don't know this, but we must be knowing what are the fundamental rights and what are the rights given under that. By just reading them, providing equality and right to life and liberty, all these are what? It will prevent the authoritarian rule. So this is also correct. So if 2 is correct, A can be eliminated. Next, 3. Protect the liberties and freedoms of the individual. Here the word is freedoms. Freedoms, and in fundamental rights we have freedom rights under Article 19. So by that we can say this is correct. So 3 is correct. If 1, 2, 3 are correct, answer is D. But let us go through fourth point also. Fourth point says aims to achieve the objective of economic justice. Economic justice, where is it mentioned? Is it there in fundamental rights or there in other parts? We have this under DPSP. So we can eliminate this. So answer becomes D, 1, 2, 3. Here in the explanation, answer is given as D and value addition points are given over here. Fundamental rights are described as Magna Carta of India. They provide political democracy. DPSP is to achieve social and economic justice. So, please write down the differences between fundamental rights and DPSP. From this section, there's always one question asked in every year prelims, either regarding fundamental rights or DPSP, or in most cases the differences and similarities between the two. So read about this carefully. Next question in polity is given under question number 2. This question is regarding fundamental rights again. Let's read the question. Which of the following statements is or are correct regarding the fundamental rights? So we need to see which of these statements are correct. First, let us go through the options. A says 1 and 2, B says 2 and 3, C says 1, 3 only, D says none of the above. It means at least one statement out of these 3 should be incorrect. So let us see what that statement is. For that, we need to read all the 3 because there is no eliminating point over here. First statement says, the state can impose restrictions on fundamental right in an arbitrary way. See, such statements, even if we don't know them directly, but arbitrary is a very arbitrary word. Arbitrariness is not allowed in any form of organized societies, organized democracies. So, in our constitution, arbitrary imposition of fundamental rights won't be there. So, this should be incorrect. So, let us eliminate this. If we can eliminate this, we can eliminate these 2. Now, we have the choice between 2, 3 and none of the above. Let's read Second option, they are available. They here means fundamental rights are available to citizens and foreigners only. When the statement says only, we should be careful. But by the preliminary reading, citizens and foreigners, who else will be there? So we might think this is correct. So let's read the third statement. They are not applicable to armed forces, paramilitary forces, and police force. Here we can say that the armed forces, paramilitary forces, police forces, these are also our own citizens. So, not applicable is an absolute statement. They are applicable but are restricted. Means not all are applicable. Restricted access is there. So, we can say this is incorrect. When 3 becomes incorrect, we can eliminate this option. Answer becomes D. Let's see the explanation given for this question. Answer is given as D, and statement 1 is correct because they cannot impose arbitrarily. Statement 2 also incorrect because fundamental rights are also available to legal persons or legal entities that are registered in India. That's why apart from citizens and foreigners, for legal persons also fundamental rights are applicable. In the question, it is given only, because of that it has become incorrect. And see here, the application of fundamental rights to the armed forces, paramilitary, police forces is restricted or abrogated, means they are applicable but restricted. So 3 also becomes incorrect. Answer is none of the above. Next question given under polity is third question. Here again this is related to fundamental rights. Let's read the question. Fundamental rights are defended and guaranteed by the Supreme Court. This is the statement. What is the implication of the above statement? Implication is the keyword over here. Most of the students have attempted this question incorrectly because of not proper understanding of this word implication. Implication means there is something happening. Here, fundamental rights are defended and guaranteed by the Supreme Court. What is the result of it? That is the question. What is the result of it? Let's read the options. Option A says, Supreme Court is the guardian of Constitution. So it is the basic duty to protect the fundamental rights that are enshrined in the Constitution. It means the meaning of the statement is given in different words. Let's read option B. Fundamental rights are part of basic structure of the Constitution, so the Supreme Court has ultimate authority to defend and guarantee them. This is also the meaning of this particular given statement. Let's see option C. The aggrieved person can directly go to the Supreme Court for enforcement of his rights. This is what? What is this? This is result of the given statement. Let's say we have not inferred it directly. So we have eliminated this. We are doubt in this particular place. Let's go to D and read it. Fundamental rights are paramount and sacrosanct. So protection of rights of an individual has to be placed in the independent and credible institutions like Supreme Court. That's why they were given to Supreme Court. So this is the meaning of this statement. So option A, B and D, all these 3 are the meanings of the statements, not the result or implications of the statement. So the statement is similar to option A, option B, option D, but C is the answer because that is the implication. As they are defended and guaranteed by the Supreme Court, any aggrieved person can directly go to the Supreme Court. That is the result of it. That is the meaning of the given question. Most of the students have committed mistakes over here. Please understand this carefully. Answer is C. Here in the explanation, answer is given as C. And read this particular paragraph. Next polity question is given under question number 4. This question says, which of the following come under the definition of a state as defined under Part 3 of the Constitution? Part 3 of the Constitution is related to fundamental rights. Under the definition of fundamental rights, what is the meaning of state or what comes under the definition of state? Let's see the options. 1, 2, 2, 3, 4, 1, 3, 4, 1, 2, 3, 4. Let's read these points. public-private partnership firms. Here, public means government. So, we can say that it is related to state. Non-governmental organizations, these are not related to states. So, let's keep this aside. Tribunals, these are established by the government. So, this comes under states. Cooperative societies, these are there in our fundamental rights also. So, that will be added under states. So, we have doubt over here only. Non-governmental organizations. But the word itself says non-governmental, not related to government. So we can eliminate 2. If we eliminate 2, this is gone, this is gone, this is gone. Answer is C, 1, 3, 4. Here in the explanation, answer is given as C. And read this particular one. State is defined under Article 12 under Part 3 of the Constitution. Except non-governmental organizations, all others cover under state. Next polity question is given under statement question number 5. This says, which of the following aspects does not is keyword, underline this, does not come under the concept of equality before law. Means which violate this concept of equality before law. Here, let's read the options. If you observe, 4 is there in all the answers, in all the options given. So, 4 must be correct. Now, let's keep this aside. 4 is correct. Let's examine the other 4 options. The first option says, providing vehicles with beacon lights on top to the bureaucrats. So, this means providing some special privilege to them. So, this will not come under equality before law. So, this is correct. Second one, prior approval from the government to investigate cases against higher level civil servants. It means we are giving some privilege to them. Others, they are arresting without any permission, without any prior approval. But for these people, prior approval is needed. It means it is violating or it doesn't come under equality before law. So this is also correct for our question. Third one, providing reservation to the transgenders in the government job means we are treating them separately. It also doesn't come under equality before law. Fourth option, we said it is correct. Fifth one, setting up tribunals. Tribunals mean separate laws, separate procedures are there. So, no equality. So, this also comes under our answer. But if you observe, in our Constitution, Article 14, all these are given as exceptions to equality before law. It means we can say these will not come under or does not come under equality before law. That's why answer is D, 1, 2, 3, 4, 5. All these will not come under, does not come under concept of equality before law. Here in the explanation, answer is given D, and the concept of rule of law, equality before law is explained over here, and then with regard to each option, description is given over here. The next question in polity is given under question number 17. This question is with regard to federal system of government and then features of this federal system. Let's see the options 1, 3, 1, 2, 2, 3, 1, 2, 3. So at least 2 statements would be correct in this. Let's examine the points given over here. Article 1 of the Constitution describes India as Federation of States. Is it true? No. India, that is Bharat, is Union of State. Union of States. That is what is mentioned under our Constitution, Article 1. So this is wrong, incorrect. Second statement is the Constitution allowed no state to secede from the federation. Yes or no? What is the meaning of it? By resolution, a state itself can't secede from India. This is correct. Third one, the appointment of governor by the center is the most significant feature of federal system of government. Appointment of governor by the center means center is having more power with regard to states because head of the state is governor. So he or she is being appointed by the center. It means the independence or freedom for the state is not there in this particular case. Center is having more power. That is not a feature of federalism. So this is also not the feature of federalism. But here in the question 1, 3, 1, 2, 2, 3, 1, 2, 3 are given. Only 2 is correct. So the question here is incorrect, not correct. Please change this. So when we say incorrect, then the answer becomes 1 and 3. Answer is A. This is incorrect option. So in the answer it is given A correctly, but in the question this word in was not printed because of some printing mistake. So please correct that. And this is the explanation given for that. So this question is asked based on the features of constitution. Every year we are getting at least one question from this particular part, that is features of constitution. Please be prepared and read our 11th class political science textbook and read Indian Constitution at Work. This is one NCERT, Indian Constitution at Work. Here you can get some insights. By just reading Lakshmikant, we may not get the analytical information, but by reading these NCERTs, we will get the insights regarding these features of the Constitution, how they are working, etc. Next question given under Polity is 18th question. Let's see what the question says. Which among the following statements about the Indian Constitution is true? We need to identify the true statement. Let's go through the options. A says communal representation in the executive. Is it there in our constitution? No, never. Communal representation was there earlier, prior to our Indian constitution, during British India, not in the executive, but it was there in legislature, but now we don't have it. So let's remove this. B says provision of fundamental duties in the original constitution. We have fundamental duties in our constitution, but it is not under original constitution but added through 42nd Amendment Act. So this is also not correct. Extremely flexible in nature. Our constitution is extremely flexible, means we can amend as and when required. But if you see the constitutional amendments under Article 368, they have requirements, they have different kinds of majority, special majority, simple majority, special plus half states ratification. This is not extremely flexible. This is flexible but not extremely flexible. If you compare USA, India and UK models of constitutions, USA is very difficult to amend, India moderate, UK is very flexible to amend. So we can't say it is rigid, we can't say it is flexible. It is moderate. It is not extremely flexible. So let's remove this. D should be the answer, but let's read that. The control of states by the center at specific times. It means what? During emergency. What happens? Center controls states. So, this statement is correct. Answer is D. The control of states by center at specific times. Here in the explanation, answer is given D and it is explained in detail over here. Please go through it once. Next polity question is given under question number 19. This question is about preamble and we need to find the correct statements. Here in the answer, if we see 1, 2, 3, 2, 3, 4, 1, 3, 4, 1, 2, 4. So 3 options are correct. 1 must be incorrect. Let us identify what is it. Preamble is not part of the constitution. Is it true or not? Let's say we don't know this because in some cases Supreme Court said it is not part, in some cases it said it is part of the constitution. So let's keep that aside for some time. Let's go to option 2. The basic features of the preamble cannot be amended under Article 368. This basic features is part of Keshavananda Bharati judgment, where Supreme Court told basic features of any part of the constitution cannot be amended under Article 368. So this is correct. Then third one, preamble can be amended under Article 368. Fourth one, the original preamble document had no mention about the term integrity. Yes or no? If we know 42nd Amendment and what were added through this, Socialism, secularism, unity and integrity, we can say this as correct. 4 is correct. 2 is correct. Let's see 4 and 2 where they are there. 4 and 2 are there in B, 4 and 2 are there in D. So we should know particularly about this. For that, we have this particular case known as Keshavananda Bharati case, very significant case in terms of India's legal evolution of the constitution. In that particular case, Supreme Court said that preamble is part of constitution, so this is incorrect. Basic features of preamble cannot be amended, so this is correct. Preamble can be amended under 368. These three have been told in the Keshavananda Bharati case, but as it has given not, this becomes incorrect. 2, 3 correct. Even if we don't know fourth one, we can eliminate one. Answer would be B. Let's go through the answer. Answer is given B and explanation is given over here why each option is correct or incorrect. Next question under polity is given under question number 20. This question is asking which of the following were not present in the original document of constitution. So not means they are not there. Let's see, it means they have been added. Indirectly we can say what are added later to the constitution. That is the meaning of this question. Fundamental duties, were they added or not? Yes. Under 42nd Amendment Act, added. Secular, yes, added under 42nd Amendment Act. Sovereign, no. Socialist, yes, again under 42nd Amendment Act. So answer is 1, 2, 4. That is answer is D. Here in the explanation through what amendment when it was added is given. Please go through it once. Next polity question is given under question number 21 in your question paper. This question says which among the following is or are features of secular nature of the state, especially with regard to Indian constitution. What are the secular features? That is the question. Let's go through the options. The first option says the constitution provides for an individual the right to freely propagate any religion anywhere in India. Anywhere is the keyword over here. We know from the fundamental rights, right to free propagation is there. But anywhere, this is the keyword we need to underline. Anywhere means can free religious propagation can be done in government offices or in other religious institution? These are the questions we should ask. Here, anywhere, because of this one single word, this option becomes incorrect. Next one. No religious instruction shall be provided in any educational institutions, including those established by religious minorities. Here, any is the keyword. In polity, be careful while answering such questions. These are known as absolute terms, anywhere, any. When such words occur in the options, be careful. So, because of this word and religious minority institutions, can't we propagate religious instruction? Yes, we can propagate. So, because of this and this option also becomes incorrect. That's why answer is D, neither 1 nor 2. Let's go through the explanation. Here they have mentioned why 1 is incorrect, why 2 is also incorrect. Please read that. Answer is D. The next question in polity is given under question number 32. Here, let's read the question. Directive principles of the state policy in Indian constitution are a reflection of ideals enshrined in constitutions of what? When we see this DPSP, we will directly know this is from Ireland. So, most of us keep 2 only as the answer. But then, if we carefully read from Government of India Act, Instrument of Instructions, from this particular act, Instrument of Instructions are taken and are added under DPSP. So, this also becomes part. So, 2, 3 are correct. But we should know one factual information that Ireland has taken their DPSPs from Spain. So, Spain also becomes correct. 1, 2, 3, all are correct. Answer is D. Most of us have attempted this question incorrect because We have just read this and kept A as the answer. So please be careful while answering such factual questions. Here in the explanation, answer is given D. It is given Y. All three are correct. Next polity question is given under question number 33. This question says, Supreme Court ruled that fundamental rights and DPSP are in fact supplementary to each other and together constitute integrated scheme. So we need to identify which doctrine is this. So just read all the doctrines. Pith and substance. Let's say we have not understood it. Leave that. Doctrine of eclipse. Eclipse means something is removing some other things for some period of time. That is the English general meaning of this. So we can say this might be incorrect. Doctrine of severability. Let's say we have not understood this. Next D. Doctrine of harmonious construction. Harmonious means living together or coming together. By preliminary reading of this thing, fundamental rights and they are supplementary and together is the word over here. So even if we don't know this directly, we can say this is as the answer D, because among all of them this is more relevant. And Supreme Court also told under doctrine of harmonious construction these two are interrelated, because political rights without socio-economic rights are waste. Socio-economic rights without political rights are not necessary. So these two should be together. That's what is told under doctrine of harmonious construction. In fact, Supreme Court in Kerala Education Act, Kerala Education Bill Act and Minerva Mills case, in these two cases have told that doctrine of harmonious construction between fundamental rights and DPSP is applicable. So here in the explanation, what is the meaning of this doctrine of harmonious application is mentioned. The next question under polity is given under question number 34. This question says, Constitution upholds the rights of labor and ensures labor welfare in which of the following ways via directive principles of state policy? That's the question. Here, let's read the options given. It says, it makes provisions for just and humane conditions for work and maternity relief. Here, this is given under Article 42. So, Article 42 comes under DPSP, correct. Second one, it makes provision to secure a living wage and a decent standard of life and socio-cultural opportunities for all workers. This is part of Article 43. So, this is also correct. Third one, it exhorts the government to take steps to secure the participation of workers in the management of industries. This has been added under 42nd Amendment Act. This comes under 43A, Article 43A. So this is also correct. So 1, 2, 3, all are correct. Answer is D. Here in the explanation, all the articles are defined. Please go through it once. The next question that is given under polity is question number 35. This question is with regard to RPA Act, Representation of People's Act, laid down certain qualifications for the persons to be chosen as a member of state legislature. What are those qualifications? That is the question. Option 1 says, a person to be elected to the legislative council. When there is bicameralism at the state level, that means legislative assembly, legislative council. This is upper house, this is lower house. In this particular case, the person that to be elected to upper house or legislative council must be a resident in the concerned state. That is given under RPA Act. Second option, a person to be elected to the legislative council to be qualified for the governor's nomination. So this is also there in the RPA Act. Third one, a person to be elected to the legislative assembly, this is lower house, must be an elector of an assembly constituency in the concerned state. So he should have the voting right in that particular constituency to be elected as legislative assembly member. This is also mentioned under RPA Act. To answer this particular question, we should correctly know whether these three are there or not. We can easily guess 3. So we can eliminate this. So 1, 1, 3, 2, 3, 1, 2, 3 are the options that we have. Here we can also guess 1 as correct because a person to be elected to legislative council must be resident in the concerned state. So if we think 1 as correct, we can eliminate this also. Now 1, 3, 1, 2, 3. So to answer this, 2 is the key over here. So without knowing this, we can't answer this particular question. So if we read this chapter on qualifications of state legislature, members of state legislature, we can answer this. So answer is D, 1, 2, 3. The explanation for this question is given over here. Please go through it once. The next polity question is given under question number 36. This says, consider the following statements regarding the Constitution of India. First one is Article 1 describes Territory of India. Territory of India is a broader term. Option 2 says the term Union of States includes not only states but also union territories. For that, we should know what are the categorizations under Territory of India. Under Territory of India, we have Union of States, which consists only of states, and we have union territories, and we have another acquired territories, if any, in the future. So these are the 3 categories under Union Territory of India. But Union of States include only states, not union territories. So this is incorrect. This is correct. So answer is A, 1 only. Here in the explanation, what article defines, what are part of Territory of India, all these differences are mentioned. Please go through it once. The next prelims question in polity is given under question number 42. This question is asking us which one of the following pairs is not correctly matched, means which is incorrect. Here source is given, features borrowed is given. USA Constitution, impeachment of president. See, for these things we need to identify only one incorrect one. So let's say we don't know this, keep that aside. British Constitution, procedure established by law, is it correct or not? Here we have rule of law, procedure established by law, due process of law. These 3 are important terms. Due process of law is adopted from USA. Procedure established by law, let's say we don't know. Rule of law is from UK or Britain. So procedure established by law is not from British Constitution. It is by some other constitution. It is Japanese Constitution. So this is incorrect. So if we know this fact, we can eliminate all of them. This is the answer because the question is asking us not correctly matched statement. In our Lakshmikant, we have one single table where sources of the countries and features borrowed are mentioned. Please go through that once carefully. Here in the explanation, answer is given as B and Y, which are taken from which constitution, are mentioned over here. The next polity question is given under question number 43. This question is asking which among the following cases does the constitutional amendment under Article 368 is required? See, we have certain amendments under Article 3 and Article 4 which does not require any constitutional amendment under Article 368. Let's see whether any option is given here comes under these 2 articles. Admission of new states into Union of India. This comes under Article 4. So we can eliminate this. B. Settlement of boundary dispute between India and other territory or other country. This, according to the Supreme Court judgment, does not require any constitutional amendment. Let's remove this. Cessation of Indian territory to a foreign country. Let's say we don't know this. Let's go to option D. Alter the name of any state that comes under Article 3. So, by reading the first two chapters, we will understand Article 3, Article 4. They do not require any constitutional amendment under Article 368. So, A and D directly removed. B, through the constitutional and interpretation of constitution by Supreme Court, we can remove this. So, left out is C, that is correct. C is cessation of Indian territory to a foreign country that requires constitutional amendment under Article 368. So in the explanation, it's mentioned about Article 2, Article 4, Article 3 and other Supreme Court rules. The next question given under polity is question number 44. This question says, VVPAT system is a new initiative of the Election Commission to ensure free and fair elections. This paper slip contains. What does this paper slip contains? That is the question. So this we can categorize under elections and we can categorize this also as current affairs issue. Let's see what are the options given. First option is serial number of a voter. This is a very important question because now regarding EVMs, VVPATs, there is huge controversy going on. Let's see what is printed on that particular slip. Serial number of the voter. So voter should know whether that is his or her vote or not. So this should be there. So let's keep that. Second one, name of the candidate for whom the vote has been cast. So this should be there. Otherwise, how will he or she know whether his vote is being casted to that person only or not? So this also should be there. Party name of the candidate for whom the vote has been cast. Let's say we don't know this. Fourth one, election symbol of the candidate for whom the vote has been cast. Election symbol should be there. So 1, 2 and 4 we know for sure. But 3 we don't know. Can we eliminate 3 just like that? But on the closer examination, we can see that is relevant. There are some candidates, independent candidates. So how can their party name be printed? So this is in doubt. So we cannot eliminate this for sure and we cannot keep it for sure also. But then by observing the options 1, 2, 1, 2, 4, 2, 3, 4, 1, 2, 4, 3 is there only in 2 options. So in most probable cases, we can eliminate that. Answer becomes B, that is 1 to 4. Party name of the candidate is not printed on the slip. For these questions, how to answer them? In general, Election Commission of India issues some awareness advertisements. So we should read them and read what is mentioned over that slip. Otherwise, we cannot eliminate this option of 3. Here, in the explanation, what are the features of VVPAT are mentioned over here. Please go through that once. Next question under polity is given under question number 45. This question is with regard to electoral bonds. We should identify the correct statements. Let's read the options. Here, if we go through the options 1, 2, 2, 4, 1, 2, 4, 1, 3. It means if we can eliminate 1, we can eliminate 3 options and B becomes correct. But let us see whether first one is correct or not. India is the first country in the world to have such unique bonds for electoral funding. Yes or no? This is correct because in the 2017 budget, electoral bonds were introduced and that time government said India is the first country. So this is correct. So we can't eliminate this. But we can eliminate this 2 and 4 because 1 is correct. Second one, these bonds are bearer instruments in nature of promissory note and interest-free banking instrument. It means there is no interest on them. This is also correct. Third one, an electoral bond has a life of 30 days. Whenever days, numbers are there, please be careful. Life of 30 days from the date of issue. But this is 15 days. So this becomes incorrect. Fourth one, the electoral bonds are purchasable from any branch of the State Bank of India. Is this correct? Any branch is wrong because only the notified branches of SBI, we can purchase them. So 4 becomes incorrect. So this is wrong. 3 becomes incorrect. This is wrong. Answer is A, 1 and 2 only. Here in the explanation, the detailed explanation regarding electoral bonds are mentioned. Please go through this once. The next polity question is given under question number 46. This question is regarding proxy voting that is in use. Proxy voting that is in use at the present, as per the RPA Act 1951, who among the following are eligible for proxy voting? First, armed forces, because they are not available in their constituencies, so they should be providing some proxy voting. So this is correct. 100% we will know that. Second one, government officials posted outside India, for example, high commissioners, etc. They can't cast their vote from there. So they should appoint some proxy, some person on behalf of them. So this is also correct. NRIs, most of us did this mistake. In providing proxy voting to NRIs is mentioned in news, but still not been implemented. Amendment for this act was not done. So NRIs is now not there. There is proposal but not being implemented. So 3 is eliminated. Answer is B, 1 and 2 only. Here, regarding proxy voting, few value addition points are mentioned. Please go through it. Next question in polity is given under question number 53. This question says, consider the following statements with regard to Lok Adalats. Lok Adalat, People's Court, is an alternative dispute redressal mechanism, ADRM, and settles disputes through conciliation and compromise. Is this true? This is true. Second one, Lok Adalat is presided over by a sitting or retired judicial officer as the chairman and 2 other members, usually a lawyer and a social worker. As this is a compromise, social worker can be part of it. So we can say this is also correct. The decision of the Lok Adalat is binding on the parties. When Lok Adalats give any judgment, that is binding on the parties to the dispute. This is also correct. Fourth one, parties to the dispute can appeal against the order of the Lok Adalat in High Court. See, when we say it is binding means they should follow it. If they can appeal to higher court, why is it binding? It is not binding. So if 3 is correct, 4 becomes incorrect. Or if 4 becomes correct, 3 becomes incorrect. So 4 and 3 should not be at one place. So this becomes obviously incorrect. D also becomes incorrect. We have 1, 2, 1, 2, 3 only. So as we have removed 4 from all of the options, C is the correct answer. 1, 2, 3. All these 3 are correct. Here in the explanation about Lok Adalat Act and how it is being implemented, that is mentioned. Please go through it once. Next question given under polity is question number 54. This question says, consider the following statements mentioned in the Constitution about DPSP. Let's see what are the options given. DPSPs are meant for promoting the ideal of social democracy. Yes or no? We have socio-economic goals. So social democracy is correct. Second one, DPSP are meant for promoting economic democracy. Yes or no? Just now we said socio-economic. This is correct. DPSP seeks to establish welfare state because there are many provisions for ensuring welfare of the people. So this is also correct. DPSP are justiciable means for any violation of DPSP we can move to court. Is this correct? No. Fundamental rights are justiciable but not DPSP. 4 becomes incorrect. So remove this. And we know that 1, 2, 3 are correct. Answer is C. 1, 2, 3 only. Here is the explanation for this question. Please go through it. The next question given under polity is question number 55. This question is with regard to 5th schedule. 5th schedule, 6th schedule. These 2 are very, very important. Let's see what is the question. Consider the following statements regarding 5th schedule. First statement is governor is empowered to declare an area to be a scheduled area. We generally have this doubt. Is it governor or president of India? So we should write all the provisions, important provisions of 5th schedule and 6th schedule in comparison, and write who declares a particular area as scheduled area, who declares a particular area as autonomous council. So such classification we should write at one place to avoid such confusion. Here, President of India is empowered to declare an area to be a scheduled area. So this is incorrect. Let's remove this and this. We have 2, 3, 3 only. Second one, provisions of the 6th schedule do not apply in the state of Jammu and Kashmir. Provisions of 5th schedule is panchayats. It do not apply in the state of Jammu and Kashmir. We know that Jammu and Kashmir has special constitution. Some features generally doesn't apply to Jammu and Kashmir. So this is correct. Part 9, that is dealing with panchayats, is not applicable to 5th schedule. Yes or no? Yes. So to apply them to the scheduled areas, we have this PISA Act, Panchayats Extension to Scheduled Areas Act. So this is also correct. 2, 3, both are correct. Even if we don't know 3, as we know 2 is correct, we can say B as the answer. So regarding this question, explanation is mentioned over here. Please go through once. Next polity question is given under question number 56. This is regarding correctly paired matches. First one, this is regarding schedules. Allocation of seats in Rajya Sabha. This belongs to which schedule? 4th schedule, not 7th schedule, 4th. So this is incorrect. Provisions relating to emoluments, allowances, this belongs to 2nd schedule. Forms of oath belongs to 3rd schedules. So these two are interchanged. Fourth one, administration of tribal areas in the states of Assam, Meghalaya, Tripura, Mizoram. This belongs to 6th schedule, not 5th schedule. So we should be careful. 5th schedule deals with all other scheduled areas except these 4 states. 6th schedule deals with these 4 states. So answer is all of them are incorrect. So neither of the above is correctly matched. So answer is D. Most students have kept C as the answer because they have got confused over here, 5th schedule and 6th schedule. So please read the question carefully. Here is the answer for this question. Next question in polity is given under question number 65. This question is with regard to Lok Adalats. Which of the following statements is incorrect? Please underline this, incorrect. First statement says arbitration is the procedure by which parties refer their dispute to an arbitrator. Yes or no? We said it is correct. B. It is a common practice for commercial contracts to contain express clauses referring disputes to arbitration. Because if we go for criminal justice system, normal courts, it takes a lot of time. So commercial contracts, they have arbitration. This also looks correct. Go to C. Any award given in arbitration is enforceable. Enforceable means is applied through every court system. So, if it is not enforceable, why do we have Lok Adalats? Why their authority will stand? So, this should be correct. Go to option D. The parties must have agreed to use the arbitration procedure before contract is signed. Need not. For example, marriage disputes. So, they need not have procedure, agreed procedure, arbitration procedure before the contract. So, this is not a precondition. So, this becomes incorrect. Answer is D. Here, the explanation is mentioned for this question. Next question given under polity is question number 71. This question, let's read the question. Which of the following statements are correct about Mandal case, also known as Indira Sahani case? Let's read the options. This question was given because of the recent reservations. Let's read the options. First one says opportunities in the public employment and reservations in legislature were dealt in the case. Opportunities in public employment, yes, but are reservations in legislature discussed? So let's keep it as doubt. 2. Total reserved quota should not exceed 50% except in some extraordinary circumstances. We all know this 50% clause and extraordinary situations. So correct. 3. It provided for 10% reservation for poorer sections among the higher castes. Mandal case was in 1992. What is this? 10% reservation for poor is recent one. EBC reservations is a recent one. So this is a wrong statement. So eliminate this, eliminate this. We have 1, 2 and 2 only. We know for sure that 2 is correct. We should read 1 again. Opportunities in public employment, yes, and reservations in legislature. Reservations in legislature were not discussed. These were already settled. Already reservations in legislatures are there. Through delimitation commission, we are reserving certain constituencies. So this is not there. 1 becomes incorrect. So this is incorrect. Answer is B, 2 only. So explanation for that question is given over here. Please go through this once. Next polity question is given under question number 72. Let's read the question. Which of the following statements is or are correct about freedom of movement as provided in the Constitution? Under Article 19, freedom of movement is mentioned. So what are the provisions in that? It restricts the freedom of movement of offenders to move out of the country. Yes or no? This is freedom of movement, move out of the country. Freedom movements under Article 19, especially the freedom of movement, this deals only with the internal movement, not moving out of country. This comes under Article 21, right to life and liberty. So if we know this distinction, we can say this is not correct. Second one, imposing of restrictions on entry into the core biosphere reserve is valid under this because right to freedom of movement or freedom of movement has some exceptions. Under that, 2 is a reasonable exception. Answer becomes B, 2 only. So, for that explanation is given over here. Answer is B. Next question given under polity is question number 73. This question is regarding right to life and personal liberty. And which of the following rights are conferred under right to life and liberty? There are a long list of rights given under right to life and liberty. We should know them. And let's see what are the options given over here. Right to privacy. This recently in the Puttaswamy case, Supreme Court said right to privacy is part of right to life and liberty. So 2 is correct. Wherever 2 is not there, let's remove them. This is not there, removed. Right to education. Is it part of right to life and liberty or is it a separate one? Third one is right to information. Is it part of right to life and liberty or not? Remember, there are certain rights which are part of other articles and also becomes part of right to life and liberty. Education, information are parts of right to life and liberty, but they also have their separate articles. Right to education is Article 21A. Right to information is implied in Article 19(1)(a). Implied means not direct but implied, but is also part of right to life and liberty. Who defines this? Supreme Court in different cases defined which rights are part of right to life and liberty. So we know 2 is correct, 1 is correct, 3 is correct. Answer is D. Here in the explanation, additional points for this question are mentioned. Please go through it once. The next polity question is given under question number 74. This question says, regarding the powers of Supreme Court and High Courts over issuing writs, select the incorrect statement. Underline this. Writ jurisdiction of High Court is narrower than that of Supreme Court. Yes or no? No, because we know High Court's jurisdiction, under High Court we can issue writs for violation of fundamental rights and other rights also, legal rights also. So, narrower means it is incorrect. The question is also asking incorrect statement. So, this is one of the answers for us. 2. Territorial jurisdiction of Supreme Court is wider than High Court. Yes or no? Yes. Supreme Court can issue writs for any part of Indian territory. So, High Court within that state only. So, this is correct. So, here it is asking incorrect statement means this will not be our answer. Only A, that is 1 only is our answer. So, the explanation for that question is mentioned over here. Please go through it once. The next polity question given in our paper is 75th question. This question says, which of the following cases cannot be challenged and invalidated on the grounds of contravention of fundamental rights? Contravention means a violation of fundamental rights. If some things are happening and if they are violating the fundamental rights, then also we cannot challenge them. What are they? That is the question. What does this mean? What are these exceptions? That is the question. Exceptions for violation of fundamental rights. Acquisition of the estates and related rights by the states. Here, this comes under Article 31B. So, even if this article is violating Article 14 and Article 19 under fundamental rights, these cannot be challenged under courts because it is introduced under Article 31B. And acts and regulations included in the 9th schedule, these have immunity over certain subjects which, when introduced in 9th schedule, cannot be invalidated under the ground of contravention of fundamental rights. This also correct. Third one, to implement the socialistic DPSPs specified in Article 39 BRC. So these, when they violate Article 14 and 19, we cannot challenge it under the courts of law. So this is also mentioned. So these three are correct. So we read this concept under DPSP versus fundamental rights. Please read that concept carefully. We can answer these questions. So answer here is 1, 2, 3, that is D. The explanation for that question is given, including the articles which deals those topics. Please go through it once. The next question given under polity is question number 76. This says, which of the following statements are correct with regard to scheduled area? Scheduled areas are dealt under 5th schedule. So, 5th schedule is very important schedule. Let's read the options. Here, if you observe, 1 is there in all the options. So, even without reading it, we can say 1 is correct. And we have 3 in 2 options, 2 in 2 options. So, we need to read 2 and 3 compulsorily. But just for the sake of reading, let's read 1 also. The executive power of center extends to giving directions to the states regarding the administration of such areas. Yes, that is there. And we know 1 is correct in all the options. Even if we don't know that, we say it as correct. Second one, each state having scheduled areas has to establish a tribal advisory council to advise on welfare and advancement of scheduled areas. Yes or no? Yes. 5th schedule's feature itself is establishment of tribal advisory council. So this is correct. 1, 2 are correct. So we can eliminate this, we can eliminate this. 3. Governor is empowered. Governor is empowered to direct that any particular act of parliament does not apply to a scheduled area or apply with specified modifications and exceptions. In this scheduled areas, governor has more powers whether to apply the laws of parliament or not. This also is correct. So answer is D, 1, 2, 3. For scheduled areas and that are mentioned under 5th schedule and 6th schedule, we should have this table. How legislative powers flow from center and states, how executive powers flow, how judicial powers flow. Likewise, we should have a table to answer these questions correctly. For that question, explanation is mentioned over here. Please go through it once. The next question given under polity is question number 77. This question is asking us regarding Article 368 and we need to identify the correct statement. Let's read the options. First option says fundamental rights can only be amended by special majority of the parliament and also with the consent of half of the state legislatures. Let's say we don't know this, but recently a constitutional amendment act for introducing 10% reservation passed. Here, our states are ratifying it or not? No. So, by that observation, we can say this is incorrect. Second one, provisions related to election of president can be amended by simple majority. Here, it is one of the features of federalism because in the election of president, Both central legislature and state legislatures are participating. So, as it is federal feature, it cannot be amended through simple majority. It needs to be amended through special majority and half states need to ratify it. So, this is incorrect. C. State legislatures must ratify or reject an amendment submitted to them within 6 months. Is there a time limit? This we should know. There is no time limit. Let's say there is no time limit, or let's say we don't know. So let's keep it aside and read option D. In case of deadlock of constitutional amendment bill, there is no provision related to joint sitting of both houses of the parliament. This is very important. For constitutional amendment bill, for money bill, there is no provision of joint sitting. So we know this for sure. So this is the answer. C, let's say we don't know it. We are in doubt. So we will not keep it as an answer. We will go for reading other option. So as we know D is for sure correct, we have kept D as correct and C is incorrect. There is no time limit. Because of that, here it's mentioned 6 months. With this word, it has become incorrect. The explanation for this question is given over here. Please go through it once. The next question in polity is with regard to 78th question. This is regarding 10th schedule related to anti-defection law. Let's see what are the options given. It was amended by 86th Amendment Act 2002. This is a factual point, but this amendment is very important amendment. What is it? It is related to right to education, and with this amendment 21A, that added right to education to the fundamental rights is added. Even if we don't know whether 10th schedule is added or not, but we know this is related to right to education. So this is incorrect. 10th schedule is added through 52nd Constitutional Amendment Act. So 1 is incorrect. 2. Any question regarding disqualification on the grounds of defection would be decided by the presiding officer of the House, and his decision cannot be questioned in any court. Most of the students have kept this correct by reading only till this. But we should read this carefully. Cannot be questioned. No, it can be questioned. It comes under judicial review. 2 also becomes incorrect. Answer is D, neither 1 nor 2. So, please carefully read each sentence given in the question. Answer and explanation is mentioned over here. In Quijotto-Holland case, Supreme Court said that President's presiding officer's decision is subjected under judicial review. Because of this, second statement became incorrect. Next question in polity is given under question number 79. This question is regarding 42nd Amendment Act and is incorrect. Underline this word carefully. First statement says 5 subjects were shifted from concurrent list to state list. We know that 5 subjects are shifted, but it is from state list to concurrent list, not from concurrent list to state list. So this is incorrect. We got the answer here itself, but let's read other options also. Article 39A was inserted. 3 new words, socialist, secular and integrity were added. Based on Swaran Singh committee recommendation, fundamental duties are added. So all these 3 are correct. Option A is incorrect. So even if we know option A is incorrect, by reading other 3 options, we got to revise the things that are added under 42nd Amendment Act. Answer is A. This is the explanation for that question. The next prelims question given under polity is question number 80. This says, according to which article, we need to identify one article, no citizen shall be denied admission into any educational institution maintained by state or receiving aid out of state funds on grounds only of religion, race, language, any of them. This comes under which rights? Minority rights. Under that, Article 29, Article 30 are there. Under Article 29, this provision is mentioned. This is very factual question. So, Article 29 is the answer. Here is the explanation for this question. The next polity question is given under question number 91. This question says, not correct with regard to DPSP. So let's read the options. They are instructions to the legislature and executive organs of the states. Yes. They seek to establish social, economic, and political democracy. Is this correct? No. But let's read other options also. DPSP helps the courts in determining and examining the constitutional validity of the state laws because DPSP mentions about welfare state, welfare rules. So this also correct. DPSP are not legally enforceable. Yes or no? Yes. Fundamental rights are not. Fundamental rights are legally enforceable, but DPSP are not. So we know that B is incorrect. So answer is B. Some students have just read till here and kept this option as correct. So read the statement completely. This is the explanation for the given question. The next polity question is given under question number 92. Let's read the question. Which of the following provisions will best facilitate achievement of democratic socialistic state? Two words, two important words, democratic as well as socialistic. To organize agricultural and animal husbandry on modern scientific lines. What is this? This is a Gandhian state, Gandhian philosophy or Gandhian ideal. Separation of powers between executive and judiciary. This is a liberal ideal. Next, equitable distribution of material resources of the community for the common good. This is a socialistic principle. D. To prohibit consumption of intoxicating drinks and drugs, those are injurious to the health. This is Gandhian principle. So what is the answer? Answer is C. DPSPs are in general classified into Gandhian, liberal and democratic socialistic principles. So we should categorize them and write them in the form of table. Whenever such questions are asked, we can answer them easily. Here is the answer and explanation for this question. The next question given under polity is question number 93. Consider the following statements. Article 330 provides reservation of seats for SCs and STs only in the House of People. Reservations are applicable only in the direct elections, not in the indirect elections. So this is a correct statement. Second one, under Article 338, National Commission for SCs was constituted for welfare of SCs. Yes or no? Yes. Under Article 338A, it is for STs. Earlier, it was only one single commission, later divided. So as both the statements are correct, answer is C, both 1 and 2. Here, explanation and answer for this question is mentioned. Please go through it once. Next question given under polity is with regard to question number 99. This question says with regard to 1909 Act, which were also known as Morley-Minto reforms. Consider the following statements. This is a very important question in polity as well as in history, modern history. Let's read the first option. It introduced the system of communal representation for Muslims and legalized communalism. So for the first time, after the formation of Muslim League in 1905-1906, communal representation was introduced under the Act of 1909. So this is true. Second one, it introduced for the first time bicameralism and direct elections in the country. Is this statement correct? No, because bicameralism and direct elections are introduced through 1919 Act, not 1909 Act. So this is false, that is true. Answer is A, 1 only. Here is the explanation. The last question given under polity is question number 100. This is our last question in this session. This question is with regard to features of Government of India Act 1935, which are not correct. Read this, underline this, not. It abolished diarchy in the provinces and introduced provincial autonomy in its place. Yes or no? Yes. It provided for establishment of Reserve Bank of India to control the currency and credit. Yes or no? Yes. It abolished the principle of communal representation. Yes or no? No. It has not abolished the communal representation. But let's read D also. It extended the franchise by providing about 10% of the total population with voting right. Yes or no? Yes, this is correct. So answer is C. This is the explanation for that particular question.